Ms. Blackman?
May it please the Court, Tara Blackman for the Commonwealth. What the Commonwealth is asking for in this case, and all the Commonwealth is asking for in this case, is an in-camera voir dire of the confidential...
Why should you get that? Why, if the judge has ordered the disclosure of the confidential informant, appears to me for very good reason, why do you have to go through this rigmarole before the information is given?
Well, I would disagree. I would say that it's not for a very good reason, and the motion judge's decision is based on two erroneous legal propositions on this case, two erroneous legal conclusions. One, that the confidential informant waived his or her Fifth Amendment privilege.
No, but that's when you're asking for the hearing. I take it initially the judge said, on the basis of this information, these defendants are entitled to the disclosure of the identity of the informant, right?
Well, but the thing is the motion judge didn't conduct a Raviaro balancing test. The motion judge erroneously decided that the confidential informant waived his or her Fifth Amendment privilege. If the confidential informant has a Fifth Amendment privilege in this case, which there's every reason to believe that the confidential informant in this case does in fact have a Fifth Amendment privilege, then there's no point in disclosing.
When judges say, on the facts of this affidavit or whatever else, this identity of this informant needs to be provided, they're not weighing whether or not that confidential informant has a Fifth Amendment privilege. It's the identity of the informant. There's no indication yet that the informant's going to testify.
Right, but the confidential informant has stated to the police that they're planning on invoking their Fifth Amendment privilege. There would be no point in disclosing the identity of that confidential informant if that confidential informant is going to invoke the Fifth Amendment privilege.
The confidential informant may have information that, forget the testimony, it's not going to be under oath, has information that these defendants are entitled to see if they can get.
But there's no reason to believe that the confidential informant does have such information in this case. This confidential informant was not a precipient witness to the crime committed. This confidential informant could potentially have exculpatory evidence, and that is precisely the reason why an in-camera voir dire is necessary in this case, to determine if, in fact, the confidential informant does have such exculpatory information.
I guess I'm confused. The judge's ruling that the identity of the informant had to be turned over,
Right.
That's not here, is it? That's not been appealed, has it?
Well, we're asking hasn't been appealed because we asked what we saw in this case after the judge.
After that ruling, you sought
that
some additional forms of relief.
Exactly. All we sought was an in-camera voir dire of the confidential informant, two-step in-camera voir dire. One to see.
Do you always do this? Do you always insist on a two-step process with your office?
No, it's not. It's not a practice of the office. We don't even know who the confidential informant is. And now, as a matter of fact,
well, the police do, obviously.
The police do, and this confidential informant represented to the police that they would invoke his or her Fifth Amendment privilege if, in fact, he or she was called to testify.
So what would the rule be if we agree with you going forward? Whenever a confidential informant, whenever the Commonwealth is informed that the confidential informant may invoke the Fifth Amendment, there should be an in-camera review by the trial judge.
If there's reason to believe that the confidential informant will be jeopardizing, is subject to incrimination, there is some evidence that there's every reason to believe that in this case, then
but isn't that going to be almost universal, because generally the CIs have their own problems with the law, so aren't they always going to claim a Fifth Amendment privilege, or very much of the time?
Perhaps they may, and I think each case needs to be taken individually, but I think that they have every right to claim that Fifth Amendment privilege.
Well, let them claim it, not through you.
But they're not claiming it through us. We're not claiming it on their behalf. We're saying there should be an in-camera voir dire, that counsel should be appointed on their behalf, and that if they do, and the trial judge should determine if they do have a Fifth Amendment privilege. We're not saying we're going to prosecute them for something that comes out. We're just not granting them immunity.
And would you agree, contrary perhaps to your brief, would you agree that defense counsel should be present at the in-camera hearing?
I would say that the preference is that the counsel is not present at this in-camera voir dire because that may jeopardize the Fifth Amendment privilege.
What?
So that creates a procedure.
How does that jeopardize the Fifth Amendment privilege?
Well, that information may come out that the confidential informant wouldn't be as protected. Their rights wouldn't be as protected. So I think that the better remedy, and the information could be in in-camera proceeding. The information asked by the judge could be sealed. But perhaps that's the best case scenario.
Well, what are you going to get in an in-camera hearing? I mean, when you have these hearings in open court, the witness simply says, I take the Fifth Amendment, in a longer phrase. But so what are you going to get at the in-camera hearing? The judge is going to say, are you planning to claim your Fifth Amendment privilege? Yes.
Well, no. Actually, I would say that the better format, just as was done in Commonwealth versus Martin, was that a better format is a question by question. Maybe there is some information that would not that does not.
Well, then the defense attorney certainly has to be there to do it question by question.
Well, the judge would do a question by question and see, just as he would in the in-camera voir dire, to determine if there's exculpatory information.
The judge doesn't know the case. I mean, this is sort of like Bishop Fuller. I mean, how's the judge supposed to know what the defense is?
Well, the defendant has put forth what the defense is. Why the defendant has told us why they want this confidential informant. This confidential informant was not a recipient to the witness in this crime. The claim in this case is not entrapment. The entire theory of defense, the entire reason why the defense wants the identity of this confidential.
Have you made any offer of proof on what the Fifth Amendment privilege might involve?
Yes, this confidential informant has said that they've been involved in several drug activities with the co-defendants in this case, that they've been involved in many drug transactions. They've purchased drugs many times from Kendra Belial. So there is much evidence here to believe, based on the affidavit, that there's several incriminating facts.
I take it part of the defense here is that Kendra Belial is putting it. She did live there. She hadn't just let these two defendants use it. And she's using them to get out from under, because she's just getting a plea agreement, out from under much more serious charges, right? Why can't they explore that with the confidential informant? I mean, why aren't they entitled to do that? Since the apartment is in her name, there's some pretty good evidence that maybe that's true.
Well, but the thing is, and that's why an in-camera voir dire needs to be
But what about
held.
an order from the judge that the witness can be examined only on the issue of Ms. Belial's occupancy of the apartment?
Right, and that's what...
At trial.
But the thing about that is we don't know. There's no dates in the affidavit of when the CI said that he was inside the apartment, of what evidence he has if he or she has to believe that Kendra Belial was living there on the dates from the indictment. Kendra Belial, this testimony may be, whatever the CI has to offer, may be, and is all in very high likelihood, cumulative of what Kendra Belial
But we don't know. It may
anticipated.
be contradictory.
It may be, and that's precisely why we need an in-camera voir dire in this situation.
But when the defendants want voir dires before trial on all sorts of issues, the Commonwealth doesn't want them, so why should there be voir dire beforehand on this?
Because we conduct the Roviara balancing test, and just as many of the federal circuit courts, all the ones that I cited in my brief, and there's a similar situation in a Seventh Circuit case that I cited, Commonwealth versus Andrus, the confidential informant. It was the same type of situation here, where the confidential informant was not a recipient witness to the crime committed, but it was possible the confidential informant had information showing bias or motive on the part of the cooperating co-defendants in the case. And the court held an in-camera voir dire to see if, in fact, the confidential informant had any such information. And when it turned out in the in-camera voir dire, the outcome was that there was no exculpatory information, and it was not necessary to disclose the identity of the informant.
Was defense counsel present at that in-camera voir dire?
I'm not sure if the defense counsel was
Would
present.
you agree with me that the judge had some discretion on whether to have this in-camera hearing or not?
I would say that...
So we're dealing with an abuse of discretion situation?
I would say that we are dealing with the abuse of discretion standard, because I would say that the judge in this case had an obligation to conduct the Graviaro balancing test. And I think it's clear that he did not do so in this case. He did not consider the Commonwealth's interest in protecting the identity of confidential informants for
But he
further
really
investigation.
did, didn't he? I mean, he made a determination, and it looks correct on the record, that this informant may have some important information for the defense.
May, and that's the key word here. It's
Well,
based on
almost certainly would, because
Well-
the informant, he or she, was in the apartment. Belial is now, trying to get out from under. Belial is saying these two defendants are the real culprits here. What does this informant really know about all this? It seemed to me the judge was on a very solid footing in saying, I'm going to out this person.
I would respectfully disagree, Your Honor. I think that what the judge does in this case in his decision is he says there's an inference of this, there's an inference of that. That's precisely why an in-camera voir dire is necessary to determine what exactly the confidential informant knows in this case. Kendra Belial's anticipated testimony was that the apartment was hers. She was living there. But then from August 8th of 2004, 2 months prior, to October 8th of 2004.
You seem to be conflating two things. You seem to be saying there has to be an in-camera voir dire to see if this CI has any information that's important, right?
Correct, Your Honor.
And I think that's already been determined. Then you're saying there also has to be one, and they can be together, because he or she might claim the Fifth Amendment on something, right?
Correct, Your Honor.
Well, you've asked, in fact, for two separate. First, to see if he's going to claim the
Right.
she's going to claim the Fifth.
Right.
And if she doesn't, or there's a finding that he can't, a ruling that he can't, she can't, then you requested a second in-camera hearing as to whether the informant has any relevant information.
So the defense counsel, clearly both of them have got to be there,
If
subject to some kind, you say, confidentiality.
subject to some type of
Because as
agreement,
was
they
pointed
will
out, the
not
judge
disclose.
doesn't know a thing about any of this, so they're the only ones can start asking the person under oath, what the story is.
Well, the judge does in fact know what the judge in this case does in fact know what the defense
Doesn't know what the defense is going to be, and very difficult for the judge to put himself in the defendant's shoes.
Right,
defense counsel's shoes.
But the only possible defense in this case, the only way that the confidential informant could have any information relating to in this case, and this is pretty much, I think, undisputed, is that the confidential informant may be able to show that Kendra Belial, the cooperating witness in this case, is lying, is the main player in this, and has a bias and a
Assume that the
motive.
judge was not previously a trial attorney. Judge has a difficult time thinking of the questions that a defense attorney might ask.
Or following up on answers that the person gives.
But I don't think so in this case, because I think that the situation is very straightforward. Either I think it's a very straightforward situation,
You
and
want to
perhaps
be able to try their case, it sounds like, so you can control how they investigate it.
no, Your Honor, that's not true. I think that what would happen if we accept the judge's finding this wrong, which is based on two erroneous legal conclusions, but if we accept that, okay, the disclosure is necessary because the defendants demands it, they don't want an in-camera voir dire, which can't possibly in any way hurt their rights, because if exculpatory information comes out, then they will be entitled to disclosure, and the Commonwealth fully agrees with that. But what we're saying here, if we deny the opportunity for an in-camera review, in this case, what we're saying is anytime defendants say they want disclosure of a confidential informant, regardless of whether they're a recipient witness or not, no, it's okay. They're entitled to disclosure because the CI may have information.
No, that's not. Of course, you know, just from your own experience, there are, I'm sure, the vast majority of times a judge does not give over the information. These particular facts seem to warrant it.
But I think the judge's decision is based on a legal erroneous conclusion that he does not have the discretion, he doesn't know of any procedure that would allow him to conduct a hearing. That's completely wrong. That's not what the Federal Circuit
First
cases
he said
say.
you get the information, then you asked for something more, and he said no.
But he said no, but he based it on two erroneous legal conclusions. He felt that he did not have discretion. That's completely wrong. In a recent case, Commonwealth versus
Did
Madigan.
he state he didn't have discretion?
He said that he knows of no such procedure other than a Franks Amaral hearing that would allow him to conduct such a hearing. And there is no basis for that. All the Federal Circuit cases show that this is the type of procedure, this is a perfect type of procedure, especially where there are concerns for safety of a confidential informant, such as there are in this case. This confidential informant has represented that they have a fear for their safety. The plea agreement between Kendra Belial and the Commonwealth.
Blackman, your time is up.
Oh,
Thank you.
thank you.
Mr. Seeger? You have 7.5 minutes.
7.5 minutes, Your Honor. Thank you. May it please the Court, Kenneth Seeger for Carl Diaz.
What would be the problem? What would be the harm to the defendant to have an in-camera voir dire at which defense counsel was present and permitted to ask questions?
Well,
How would you be harmed? I mean, it might delay the trial a little bit, but.
Well, there may be some harm there, Your Honor, because the Commonwealth is asking for an in-camera hearing. Even if counsel is present, the Commonwealth seems to be asking the trial court to revisit that initial ruling that the confidential informant has information that is helpful and relevant to the defense.
Well, may have information.
Well, that's right.
But I
Actually,
mean,
this might help you. You would get a kind of a in-camera deposition of the person, which you could use later to, if things went forward, to impeach.
I mean, I fail to see how you would be hurt by it.
Well, I
You'd
think
get a
that
crack at him, you'd see who he is, and you'd see what, if anything, he has to say, he, she.
well, the Commonwealth in this appeal has asked for some extraordinary things. They've asked for an in-camera hearing, and the Commonwealth has argued that it's entitled to a hearing, which is just discretionary by the trial court, and the Commonwealth has asked for defense counsel to be
I
excluded.
think I heard the assistant district attorney just say that it was it was a discretionary call, so I don't think that Commonwealth is arguing, at least here before us, that they're entitled to it.
She did admit that, and she does admit now, I think, that defense counsel's got to be there.
Well, the way the Commonwealth has approached this is that it has asked for an in-camera hearing, which it has argued that it is entitled to. It has asked for defense counsel to be excluded, which
Okay, well,
is quite
suppose we say
inappropriate.
that in the circumstances of this case, an in-camera hearing should be held with defense counsel present. So if we say that, how are you hurt?
Well, we're perhaps not harmed by that, Your Honor, but we're concerned that the Commonwealth is asking the trial court to go back and revisit this motion to disclose.
No, because if he had ruled no disclosure, it wouldn't even get to the next step of an in-camera hearing.
But the request was, hold this hearing. If the informant asserts a Fifth Amendment right, that's the end of the subject. That's part of the motion, right? You don't.
Well, there really are two distinct issues. There's the motion to disclose. And just to bring this into a wider perspective from the defendant's point of view, the Commonwealth is bringing its cooperating witness, Kendra Belial, and she's been given certain rewards and promises, and it's detailed in a handwritten note that's in the record appendix.
Which showed up in somebody's pocket somewhere.
It eventually showed up in someone else's pocket, but Kendra is being given an agreed recommendation for 3.5 to 4 years. And she's facing 15 years in prison, and she's being given this reward. So she has a very strong inducement to testify.
And you'll bring all that out before the jury, I'm sure.
The defendants, and at the same time, the Commonwealth is making efforts, and this is what happened in the Commonwealth versus McMillan case decided by the appeals court, and the Commonwealth is making efforts to deny access to the confidential informants. And we know exactly what Kendra is going to testify to because we have her statements, and she tries to distance herself from the entire enterprise, and she puts it all on the defendants.
And so you need the confidential informant's testimony or evidence because you believe it will indicate, and there certainly are some indications that it would indicate, that in fact this cooperating witness was indeed the person who ran this apartment, who was in charge, who
Well,
lived
exactly.
there.
And at the very least, to shed some doubt on her testimony and to
Okay,
bring in
so
a contradictory witness.
suppose
okay.
it's done your way, and the CI is called to trial. You won't have talked to him before, most likely. He's called to trial. I suppose the judge would excuse the jury if there's some intimation he's going to claim she is going to claim the Fifth Amendment. And at trial, confidential informant claims the Fifth Amendment.
Well,
You
then-
won't get to do anything with him, and his identity will have been disclosed, hers. And if there is any safety issue, there'll be a safety problem. But so how do you do better by having the confidential informant claim the Fifth Amendment at trial, if that's what's going to happen?
Well, a few answers. First of all, the safety issue should not be determinative here, because the issue of the informant's safety, and I believe this was held in Commonwealth versus Martin, does not pertain to a Fifth Amendment privilege. He can't use that.
No. I'm just saying that.
And
Of course it doesn't.
additionally, the informant cannot make a blanket assertion of a Fifth Amendment privilege.
That's the point, really. I mean, even if they assert the Fifth Amendment, there's a whole lot of different things to see if it can be asserted validly.
Right.
It may, whatever you're interested in may not incriminate them. And the judge could say, look, you can't take the Fifth Amendment on that. You've got to testify, or I'm going to find you in contempt.
And this,
It may be found that he or she has waived it, the Fifth Amendment in some respect. So there's a whole bunch of issues. It seems to me, once they've been outed, to use the word, and if the judge is correct on that, and I think he is here, then the Fifth Amendment thing ought to proceed in the courtroom.
I agree, and the confidential informant may have observations that does not incriminate himself
I
or
mean, the
herself.
safety thing is gone as soon as the person is outed. Identity is, got to be disclosed.
But the issue is that he hasn't been outed yet at this point.
And additionally, we should point out that there are additional remedies. The Commonwealth has the authority by statute to grant immunity if the Commonwealth is concerned about the Fifth Amendment privileges of the informant. The Commonwealth can file a motion and have the judge allow immunity for that informant.
Doesn't it really boil down to the fact that on this Fifth Amendment thing, the judge has some discretion, and we must decide here, did he abuse it? And your position is he really didn't. And if that's supported by the record, appears it is, that's the end of that. Now, in another case, a judge might abuse it, and we might say so.
Unless there are further questions, I would turn this over to my able co-counsel.
Mr.
Thank you.
Goggin?
I don't know how able I am, but my name is John Goggins, and I represent Mr. Whitehead in this matter.
Isn't the judge just wrong when he ruled that the witness here has waived their privilege by giving the police information? That can't be right. And if the judge is wrong about that, shouldn't we revisit his entire decision about how he managed the Fifth Amendment privilege issue?
Is the judge wrong about whether the witness waived the Fifth Amendment privilege? As a defense attorney, certainly I would assert that witness has not waived the
Right.
Fifth Amendment privilege because it's a testimonial privilege.
Did the judge really say he waived it, or she waived it, or did he say
On 55 of the-
there's no realistic chance of any prosecution?
On page 55 of the record appendix, the Commonwealth's record appendix, the judge does seem to intimate that
He
he
waived.
find that if he were to testify because he spoke to the police, that he waived, that informant waived the issue.
Did anyone point
How
out to the judge, that that is not the law?
No, I didn't see a copy of the transcript. The transcript wasn't provided. But I would tell you this, the judge also intimated that because the cooperating witness was working at the behest of the police, or producing evidence because of the behest of the police, that
The judge said, I'm looking at page 55, I find that he's waived that privilege by discussing it and informing the police about it.
I think he also discussed, there's a further discussion about the fact that the witness is working with the police officers, because they're working with it, that there was no Fifth Amendment privilege. But
Well, certainly with respect to the controlled buy, which they were given money to go in and buy the drugs, they couldn't be prosecuted for that, but that's not the point.
I think the Fifth Amendment issue in this case is just a ruse. This is a botched investigation because of the Commonwealth. the Commonwealth screwed this case up to fairly well. They have an affidavit of your typical search warrant affidavit that lays out why we have informants, and they pin it all on Kendra. And in the middle of this investigation, presumably when they execute the search warrant, that all of a sudden Kendra says, oh, it's not me, it's Louis Whitehead and Mr. Diaz. I will give you evidence. Commonwealth's assertion that Kendra Belisle is not a precipient witness is wholly inaccurate. She's the only witness from the
They
Commonwealth.
didn't, I don't think they said that Kendra Belisle is not a precipient witness. I think what they
No,
were
the
saying is the
CI.
CI is
The
not a
CI was
precipient
not.
witness.
That-
Was I
that-
misunderstood?
Okay, that the CI wasn't a precipient witness to the transactions of what they're accusing her of. The CI was certainly a precipient witness to the transactions because he was there when Kendra Belisle was allegedly selling the cocaine, or selling the drugs
For the control buy?
for the controlled buy. I mean, I don't have the benefit of the police report.
But the controlled buy doesn't implicate your clients. It was
Where's
a
the
sale
evidence-
between
Where's
her
the
and
evidence that, and I don't mean to rephrase the question back to the judges, but my reading of the record is that does not appear to be any evidence outside of what was garnered from the
Didn't
execution of the search warrant that Mr. Diaz and Mr. Whitehead, or Ms. Belisle's testimony, was engaging in drug activity. And-
But isn't it the evidence against your clients what they found in the apartment, and that they found your people there and a lot of drug paraphernalia?
They're going to have to prove that our clients had possession,
Right.
knowledge, intent, aware of all of that, and mere presence wasn't just sufficient. And the only way they get to that point, according to the record and according to the Commonwealth, is through Ms. Belisle's testimony.
Right.
The informant certainly gave up certain information that indicates that he or she was very familiar with Ms. Belisle, down to the fact of which car she was driving, where she lived, which particular apartment, that he or she purchased drugs from Ms. Belisle, and I think the phrase was numerous occasions.
But never in that apartment.
Um,
I thought
But they had-
one
That's
thing
not
he
clear.
said, I thought one thing the confidential informant said was that she never would sell from her apartment because she didn't want anyone to know where she lived. I
Right,
think
but
this
there's an
is.
information that the informant knew exactly where she
Right,
lived.
but he didn't buy from her at the apartment, at least according to what
He didn't say that he didn't buy from her in the apartment. He said her modus operandi was not to sell from the
Okay,
apartment.
okay,
There was no
fair enough.
indication
So
that,
your defense is that all the stuff that was found in there is really Miss Belisle's and her boyfriend's? Is that part of your defense?
well,
It's not your guys?
sure. I
Well,
mean,
in the affidavit, it says the confidential informant stated that there might be other people living with Kendra. Kendra has people coming and going all the time.
and sleeping there.
She's seen 3 to 4 other people in the apartment, some of them sleeping overnight. So it does seem to me that at least the affidavit suggests she's very familiar with what's going on in that apartment. So you're
Yes.
right. I mean, it
It-
seems
it-
quite relevant on its face.
Absolutely, and I think the judge was absolutely correct to find that Ms. Belisle's, the informant's information would certainly be helpful and material to the defense in this case, and that's a separate issue. And whether the judge recognized that he had discretion or not to conduct a in-camera hearing is not necessary, because I believe the cases delineating that whenever a judge has questions, the judge in his or her exercise of their discretion can have in-camera hearings. The cases that my sister refers to about, all of a sudden you bring up these motions, you have to have in-camera hearings, those cases only allowed in-camera hearings, including the federal case that I can't think of off the top of my head out of Chicago, only allowed them where it was not clear from the record that evidence would be shown to be helpful to the defense.
And surely in those circumstances, you would agree that the court has the discretion to have an in-camera hearing to explore this before requiring the disclosure,
I
correct?
would suggest to you, Judge, that when it's clear from the record that there's helpful evidence, such as here in this affidavit, there is no need for an in-camera hearing.
Understand, but the court still, in its discretion, could have an in-camera hearing if the court was uncertain about it, right?
I would agree with that.
Right? But with respect to the Fifth Amendment privilege here, I guess I go back to what Justice Cowan was saying. I mean, it strikes me that this witness probably has a very strong Fifth Amendment privilege. Why shouldn't the judge make that decision? You're saying the judge should give the disclosure to the defendant, then if and when she's ever called as a witness, you can deal with the Fifth Amendment privilege issues? Is that in essence?
I think the distinction between disclosure and invocation of the Fifth Amendment privilege is the biggest dichotomy in the world. There is a vast difference between the two. Disclosure allows defense counsel not only to go up and interview the witness where the witness doesn't have necessarily a Fifth Amendment privilege at that time, but also to investigate that witness, to find out other reasons or other people that that person may have associated with. And that's a far different cry from saying, well, because the informant's going to invoke the Fifth Amendment privilege, therefore
Yes,
we don't have to
okay,
disclose.
but if you, suppose you have the in-camera hearing before the trial, and the informant claims the Fifth, you've had disclosure by that time, then you'll know who the person is, I assume, although maybe you're not given the name at it.
We're talking about fundamental fairness.
No,
here.
and then you can go out and investigate the person.
You
And it's
can.
all pretrial still.
Right, and I would suggest to you that we're talking about fundamental fairness here in the Commonwealth to allow a recipient witness that they're using, their government witness, to invoke a Fifth Amendment privilege where it's fundamentally unfair, Your Honor. And I think if you look at the Rivario case, you look at the McMillan case, and
I'm sorry, did you
especially
say to invoke a Fifth Amendment privilege?
Well,
To
if the
allow
witness
the
is
witness to invoke the
testifying in
Fifth
the
Amendment
in-camera
privilege.
hearing under oath, the witness is going to have a Fifth Amendment privilege.
Right?
So
It can
he's
be
not going to get the information.
Also at the
Right.
You
trial.
can grant judicial immunity, the Commonwealth can grant immunity, but there's a fundamental fairness. And if the Commonwealth is...
No, I'm sorry, I'm really misunderstanding your argument. You say that it's unfair for the confidential
Commonwealth.
informant to assert their privilege?
It's
It would be unfair?
No, he's saying
unfair.
he should be able to investigate. He won't be able to use the test. I mean, you've got to deal with the Fifth Amendment question if you're going to want that person to testify. But
Correct.
you should be able to
I understand your
talk to
argument
the person.
now. I understand your argument.
Right, I agree, with the respect to investigation upon disclosure, but with respect to the Fifth Amendment privilege, I think it's fundamentally unfair to allow this witness to have fear of prosecution for which she's a recipient witness when the Commonwealth is using her basically as the sole evidence against our clients.
Okay, now there are, so you're talking about Belial now? You're not talking
I'm
about
talking
the...
about Belial, and that the Commonwealth is giving into this putative Fifth Amendment privilege that she may have from selling these drugs, of which she
Not
owes...
giving, Belial doesn't have any Fifth, I mean, she has a Fifth Amendment privilege, but I don't think that's an issue in this case.
She's got a promise for a plea bargain.
Right.
Okay, thank you.
Thank you.
Oops.